Good evening and welcome. My name is Rick Mullaney. I'm the director of the Public Policy Institute here at Jacksonville University, and welcome to the 4th Annual Hesburgh Lecture. We're very pleased to have all of you here. The Public Policy Institute, in partnership with the Notre Dame Club of Greater Jacksonville, has been hosting this lecture series for 4 years, and we are very pleased to here at Jacksonville University. And I will tell you, in the past, we've had some outstanding lectures, but quite frankly, I think tonight's will be the best yet, and it is certainly the most timely. As everyone knows, the president, Barack Obama, was here in Jacksonville today. The Republican nominee for president, Donald Trump, was in Jacksonville today. And on Tuesday, 5 days from now, there'll be an election in which the future of the Supreme Court hangs in the balance. Very important topic, and that's the one we have for tonight. It's a great topic, and I hope you're going to enjoy tonight's discussion. Before we get to that discussion, this lecture series wouldn't exist except for Pat Kilbane. As all of you know, he's the president of the Notre Dame Club of Greater Jacksonville. And so Pat came together and we put together this lecture series. We think it's a great annual event. And it just so happens, when he was in law school at Notre Dame, he had Professor Barrett as his teacher. So not only is he the president of the club, the person responsible for putting this together, he was a student in her class. He is the perfect person to introduce our tonight's special speaker. So I'd like to introduce Pat Kilbane.
It's always fun to do an introduction when you don't even need a paper or notes to introduce the person, but I want to make sure I don't leave anything out. And it's really fun to see Professor Barrett when a 3-hour exam is not going to follow my visit with her. So Professor Amy Coney Barrett is the Diane and M.O. Miller Research Chair in Law. She received her undergraduate degree from Rhodes College in Memphis, Tennessee, where she received that degree magna cum laude in English literature, and then she received her Juris Doctorate degree from the University of Notre Dame, summa cum laude, where she won the Hoynes Prize. And to translate that means that she was the top graduate in her class. And going from Notre Dame, she went to clerk for Justice Lawrence Silberman on the United States Court of Appeals for the D.C. Circuit. And then she chased that with clerking for the late Associate Justice of the United States Supreme Court, Antonin Scalia. Following her work with Justice Scalia, she worked at the Miller-Cassidy law firm in Washington, D.C., where she had a litigation practice at the trial and appellate level. She did appellate work also. Professor Barrett's scholarship focuses on statutory interpretation, constitutional law, federal courts, and in fact, she was appointed by Chief Justice John Roberts of the United States Supreme Court to the Advisory Committee for the Federal Rules of Appellate Procedure. She's one of those professors. I actually had her for 2 classes. She doesn't remember. I had to remind her when we were setting this up. She's that professor who's elected year after year by her students to give the commencement addresses, to be who receives the award for being the outstanding professor. So it's truly a blessing to have her here, especially as Rick said, during this timely season, where one of the major issues for many voters, especially me, is which one of these candidates is going to get to appoint Supreme Court justices. So I can't wait to hear her take on that. And lastly, Professor Barrett makes her home with her Notre Dame alum husband Jesse in South Bend with their 7 children. So, Professor Barrett, welcome to Jacksonville.
I'm going to talk a little bit about Justice Scalia and what his absence from the court will mean, and then shift and talk in a broader brush about what's coming for the court and what the election will mean for the court. And I know I have a room that's mixed, some lawyers and some not, so if the lawyers will forgive me, I'm going to try to pitch it so that the non-lawyers can follow along as well. Justice Scalia's, it's hard to overstate the influence that he had on the court and the hole that will be gone with his passing. Yes, Justice Scalia was a conservative, and so it's often said he was on the conservative wing of the court. But I really dislike the use of that word in this context, and he would too. Translated, to say that he was a conservative doesn't refer to partisan politics. To say in the context of constitutional law that Justice Scalia was a conservative described his approach to the Constitution and his approach to the judicial role, not a party affiliation. Justice Scalia's approach to interpretation of both the Constitution and statutes, and that's the grist for the mill for a federal judge, is interpreting federal statutes and the Constitution. His approach very much emphasized the primacy of the text. His view was that if you're talking about the Constitution as a text, that the Constitution means what it meant to those who ratified it. As people would have, he interpreted the text as people would have understood that text at the time it was ratified. So for the original Constitution, we're looking at the late 18th century understandings. For the Civil Rights Amendments, we're looking at the post-Civil War Reconstruction period understandings. But his rationale for that was democracy, that this is the enacted text. It went through the process of ratification or a constitutional amendment to become a law. And if we change the law now to comport with our current understandings or what we want it to mean, then it ceased to be the law that has democratic legitimacy. So he believed that change should come from the democratic process, that change from the Constitution should come through constitutional amendment, and statutory change should come from Congress or state legislatures. That the Constitution didn't call all the shots, that change and social change, the Constitution set a floor below which we can't go, but that above that floor, there's a lot of room for democracy, for the people to add additional protections and to make changes. So Justice Scalia resisted the notion that the Supreme Court should be in the business of imposing its views of social mores on the American people. He thought that things that the Constitution didn't declare off limits were up to the people to decide. His view of this emphasis on text and the emphasis on textual meaning as it was understood at the time of its ratification in the context of the Constitution or statutory enactment in the context of legislation distinguished him from those we might characterize as the liberals on the court. And I give the same caveat here. We're not talking about partisan politics. We're talking about the word liberal capturing an approach to constitutional interpretation. And that approach, which Justice Stephen Breyer is a good example of it. Justice Scalia and Justice Breyer went out on the talking circuit and they often sparred about the approaches to constitutional interpretation. So Justice Breyer's approach is much more pragmatic. So he starts with the text, be it of a statute or a constitutional provision. He begins with the text, but as Justice Breyer describes it, the text is a starting point but not an ending point. And sometimes it makes sense to push the text in a different direction in a way that makes sense to the judge, that the judge will think leads to a more sensible result. So that's kind of a nutshell version of the living Constitution approach, and it stands in contradistinction to the originalism or textualism of Justice Scalia. Justice Scalia was an extraordinarily effective advocate for his approach to interpretation because he was very smart and had an outsized personality. He really was brilliant. It was intimidating working for him. You know, when he called you in his office, you had to be prepared to just go to the mat and talk about whatever it was, and he was always 5 steps ahead of you. So he had a massive intellect, but then he didn't express that intellect only to lawyers. It wasn't just in the United States reports and judicial opinions. He wrote books that were accessible to popular audiences. He went out and gave speeches, and so he made his ideas and his approach to the Constitution and his ideas about the judicial role accessible to non-lawyers. He once remarked that the reason why he wrote dissents and separate opinions, concurrences, is because he wanted to get them in the case books. And he was a colorful writer. He was an excellent writer. And so casebook authors would include his dissents and separate opinions because they were so engaging and so clear. And then that influenced law students who read them. So his influence on generations of law students has been great, and his influence on the public debate has been great. So the significance of his seat, it's an empty seat on the court, and it has the potential to flip the balance on the court between these two camps of judges who take a more expansive approach to the Constitution and judges who take a more textual approach to the Constitution. But the symbolic significance is that it's his seat. So he is the face, really, and he is the face of this originalist, textualist approach to the Constitution. And so if President Obama had successfully, and I think at this point it's unlikely that President Obama will be the one to name the successor to Scalia's seat. But if Hillary Clinton or President Obama names the successor to that seat, it's not just that it was held by a conservative justice, one who took this more conservative approach to the judicial role, but that it was Justice Scalia. So the symbolic nature of that flip would be significant. I want to talk a little bit more broadly about what the election means for the composition of the court more generally. Justice Scalia's seat is getting all the attention because it's the one that stands vacant. But the reality is that the next president will likely get 4 appointments. Justice Scalia's seat is empty. Justice Ginsburg is 83. Justice Breyer, Rick, help me, is he 79? 78. 78. And who am I? Oh, Justice Kennedy is 80. So that's 4 seats. That's the last president who got 4 nominations was Nixon. So this could be a sea change. Now you're talking about Justice Scalia, who took this very kind of rigorous textual approach. Justice Kennedy is a fellow traveler of the court's textualists in statutory cases, not always in constitutional cases. He's obviously the notorious swing vote in constitutional cases. But he's a swing vote. He can go either way. Ginsburg and Breyer are much more firmly in the camp of the more expansive approach to constitutional interpretation. So let's imagine President Clinton. If she replaces Ginsburg and Breyer, she will do so with much, much, much younger justices who then will likely have a very long tenure in the court in front of them. Okay, that will be quite significant to the court. If she replaces Justice Kennedy with a pick, it's going to be someone who, I mean, Justice Kennedy is a swing vote. Sometimes he votes with the more conservative wing of the court, sometimes with the more liberal wing of the court. And again, I'm using those terms in their interpretive sense rather than their partisan sense. But Hillary Clinton would not appoint someone who would be a swing in those cases. It would be someone who was always very firmly on the side of those who interpret the Constitution more expansively. So we would be talking about a very marked shift. It would be a court that was very, very liberal and took a very expansive view of the judicial role. What would we have in a Trump court? Who knows? I think we know for sure. I could say with confidence, I don't know who Hillary Clinton would appoint, but I can say with confidence the profile or the kind of constitutional approach she would want. Trump, I'm not so sure. He's offered a list, and his list is populated with people who would take a more Scalia-esque approach to the Constitution. Who knows if he would choose from that list or not? He's obviously not bound to do so. I think it would be maybe more of a mixed bag. I think maybe Trump would appoint some that were more in the mold of Scalia, maybe some more in the mold of Kennedy. Who knows? I think we may well end up with a moderate to more conservative court on judicial role. I think it is safe to say it probably wouldn't be as hard to the left-leaning side on the approach to constitutional questions as Hillary would. Before Rick and I start, the next segment, the final thing I want to say about this question of partisan politics and the court is that Justice Scalia thought it was so important, and if voters could really absorb it, it's hard because voters and people generally see the headlines in newspapers, court decides in favor of same-sex marriage, or court strikes down Texas abortion restrictions. It's just the headline. It's just the bottom line. It doesn't show any of the reasoning and the hard analysis that the court goes through to reach that decision. And I think it leaves voters with the impression that justices and judges are just casting votes based on the policy results that they prefer. I'm pro-life, or I'm pro-same-sex marriage, or what have you, whatever the hot issue is on the court that term. But that is not how judges see their role. It is certainly not how Justice Scalia saw his. And one there are a couple of really stark examples of this that I think show, in Justice Scalia's case, the divergence between partisan politics or political preferences and adherence to the rule of law. And to me, that's the quality that we should be looking at when we think about what justices would fill these vacant and soon-to-be vacant spots on the court. Justice Scalia, before he was on the court, was in the Reagan administration. He was in a law and order Republican administration that was tough on crime. And as you know, in his former life as a Republican in the Department of as an official in the Republican Department of Justice, I'm assuming that his personal preferences may have leaned more towards the law and order side. But he was one of the most consistently pro-criminal defendant justices in constitutional criminal procedure cases because he thought the text of the Constitution required it. And so he was constantly voting with the, quote, kind of more liberal justices in cases interpreting the Sixth Amendment's right to confront witnesses, in interpreting the Fourth Amendment search and seizure clause, interpreting the extent of the jury trial right and sentencing, because he thought you went where the law took you. You followed the rule of law, not your partisan preference. An example that was close to his heart was Texas versus Johnson, which was a flag burning case. Justice Scalia, and I think I heard someone describe this once as something that would be difficult for someone not in his generation to fully understand the gravity of it. Texas versus Johnson involved a case challenging state law, Texas law, that made it illegal to desecrate the flag. Many states had such laws, and Johnson, in this case, had desecrated the flag. Justice Scalia voted with those justices who held that he had a First Amendment right of free speech to desecrate the flag. That was very painful for Justice Scalia. And to me, not that I would desecrate the flag, but I think not what what my grandfather said, who was a World War II veteran, was that you just can't understand the deep significance, the pain, that it wasn't just, wow, I don't like that result, but kind of the emotional wrenching that it was to cast a vote for a result that he really found painful, that he abhorred, but he thought that's what the First Amendment required. And I think those examples really show what we want in a justice. Someone who applies the law, who follows the law where it goes, and doesn't decide simply on the basis of partisan preference. Rick, I know you had some questions that you wanted to present.
Professor Barrett, I'd like to put this in a little bit of a historical context. We had a chance to talk yesterday, and I want to talk a little bit about the arc of history, because something you said yesterday was really striking. I want to put what 5 days, the next 5 days, what happens on Tuesday, means to the future of the country and the future of these decisions, not by looking forward just yet, but by looking backward. One of the things you said, and I'd like for you to comment on yesterday, was that the last time there was a liberal majority was during the Nixon administration. So can we look back a little bit over the last sort of 40 years and sort of describe the composition of the court, and then describe what's at stake next Tuesday?
Sure. Nixon got 4 appointments. Now, it's a little bit, so a lot of people say, well, the last president who could really shape, the last time we had a majority of Democratic appointees on the court was prior to Nixon, okay, which is true. Nixon had 4 appointees. It's a little bit difficult to say because, and this has been particularly true of Republican-appointed justices, they haven't always turned out to take a conservative approach or take kind of a very text-based approach to the Constitution, right? So it included in Justice Stevens was a Ford appointee, but he was a Republican appointee. But he was very much in the camp of the more expansive judicial role type judges. Blackmun was a Nixon appointee, so he was a Republican appointee. Justice Souter was a George H.W. Bush appointee, but timed his resignation so that President Obama would get the appointment because Justice Souter was also very much more kind of an expansive judicial role. So it's not always easy to say, do we have a primarily conservative or liberal court simply by looking at whether the majority of the sitting justices were appointed by Republicans or Democrats. I think that with the Nixon appointments, there was definitely a move in the court, and Carter didn't get any. And then when you see Reagan come in, that's where you had the real definitive shift. That's where you got Justice O'Connor, Justice Kennedy, Justice Scalia. You had a conservative majority. You had an active and energized conservative majority on the court. Justice Thomas was then appointed by George H.W. Bush, and Justice Souter. That was, Justice Scalia went on the court in 1986. So I think in those years before, Rehnquist was appointed by Ford, and that was also kind of a push towards the more restrictive judicial role type court. But you really had it kind of decisively accomplished in the Reagan years. So you're looking from 1986 to the present. That's at least, we're talking a pretty healthy stretch, so we're looking at least 20 years. I think it's also important to recognize that part of what Nixon was getting at, Nixon promised to appoint strict constructionists, judges that would really enforce the Constitution as written. And by the way, Justice Scalia would roll over in his grave if he heard anyone describe him as a strict constructionist, because his view was that you don't interpret the text strictly, you don't interpret it expansively, you interpret it at the level of generality with which it is written. But strict constructionism was a term that got thrown around a lot because it was a reaction to the Warren Court. So the Warren Court had been very active. I mean, it had really been the living constitutionalism court. Before that, this idea of a living constitution really wasn't around. And so when Nixon came in and said he wanted to change the court, it was in response to what a lot of people saw at the time as a court run amok, that the Warren Court was inventing all of these rights.
In broad terms, some commentators talk about sort of the arc of the court, that from the FDR and Harry Truman, that it certainly was liberal for many decades, that a transition started with President Nixon. And as you've mentioned, for probably at least 3 decades, going back to 1986 and maybe beyond, you've pretty much had more or less, like you could say, a conservative majority. Mm-hmm. Is that a fair statement?
Yeah.
Now I'd like to talk about what's happening next Tuesday. You mentioned earlier something that I think is really true. I mean, the focus of the nation tends to be on the replacement of Scalia, because that's the 5-4 tiebreaker. But what's being missed, as you mentioned, I'd like you to comment on those 2 things. Not only the ages of the 3 older justices, Ginsburg, Kennedy, and Breyer, but how youthful the more liberal judges are. Kagan at 56 and Sotomayor at 62. Meaning that isn't it very possible that you could have a liberal majority for the next couple decades and beyond based on what happens next Tuesday?
Absolutely. And I mean, I think that I think one reason, so there's a lot of speculation, and I don't have a crystal ball, so I don't know if Hillary Clinton wins, whether she would stay with Merrick Garland or choose someone else, but I suspect she would choose someone else for youth, because a president can shape the court. Merrick Garland is in his 60s, 61, 62, I think, in his early 60s. A president has a bigger impact on the court the longer the justice he or she appoints stays in office. And Merrick Garland, I think, I read an analysis by a former Supreme Court clerk who's a Democratic policy advisor. He said, oh, no, she should just focus on getting through controversial legislation in Congress and not fight the Garland nomination battle, because he will do everything she wants him to do. He will be solidly reliable in every high-stakes constitutional case, because he would take this approach that the Constitution should translate into kind of prudential judgments by justices. I don't know if she would or not, because even if Merrick Garland, who is by all accounts a wonderful man and an excellent judge, even if he would be reliable and shares her judicial philosophy in a lot of these high-stakes questions, he doesn't excite many parts of the base. He's a little boring in that respect. So she would have an opportunity to energize her base and to put in someone who is much younger. And then absolutely, Rick, you have a pretty long living court. Justice Scalia was on the court for almost 30 years, and he was appointed in his early 50s.
So it could represent a significant change over the last several decades. And to give that a little bit of meaning, what I'd like to do is to ask you a question that arises from the 3rd presidential debate. Chris Wallace asked this question, which I think relates to how you select judges. and what it might mean. In the third presidential debate, you may remember Chris Wallace asked each candidate, what criteria are you looking for when you go to pick the next justice? And I'm giving you a real shorthand of a couple of the answers. Hillary Clinton mentioned she wanted someone who protected individual rights and minority rights. Donald Trump mentioned he wanted somebody pro-life. Neither of these, of course, are very Scalia-like. And so I'd like you to comment on that versus the selection criteria based on your view as a constitutional law professor as to what we're looking for in a U.S. Supreme Court justice.
Those kinds of answers are, I think, what's wrong with our nomination process. To say, I want to appoint someone who's pro-life, or I want to appoint someone whose primary focus is protecting minority rights. Though the candidates are talking to their bases and talking to the electorate and saying, signal, I'm going to put people on the court who share your policy preferences. As I was saying before, I think that's not the right qualification for a justice. I mean, we shouldn't be putting people on the court that share our policy preferences. We should be putting people on the court who want to apply the Constitution. And by the way, on the individual rights or the minority rights, when the Constitution demands that minority rights be protected, that's what we want justices to do. That's their job. I use the example with my constitutional law students of Odysseus resisting the sirens. That the Constitution is like, Odysseus ties himself to the mast to resist the song of the sirens, and he tells his crew, don't untie me no matter how much I plead. That's what we've done as the American people with the Constitution. We've said, it's the people sober appealing to the people drunk, that when you are tempted to get carried away by your passions and trample upon the First Amendment rights or minority rights, this document will hold you back. And it's the job of the justices, of judges generally, but then ultimately the Supreme Court, through the exercise of judicial review, to tell us, like in the flag burning case, we understand, you people, you American citizens, that you want to protect your flag, but you've made a more fundamental commitment to free speech that ties your hands, and you can't do so. That's what it's about. It's not about, I like flag desecration, I don't like flag desecration. It's about, are you going to enforce the limits that are there? But then, if the people do something you don't like, if it's not one of those situations where the hands are tied, Odysseus is tied to the mast, that you have the courage and integrity to say, I'm not going to interfere in the democratic process. If the Constitution doesn't restrict your ability to do electorate, what you've decided to do in this particular statute you've enacted, then I'm going to not interfere. I will resist the temptation as a judge to impose my preferences on you and say that you are limited in the policies that you want to pursue.
This is an aside. Justice Roberts in his confirmation hearing talked about the role of being an umpire. And I guess if you were an umpire, you couldn't be pulling for the Cubs or the Indians last night. You just had to call it a ball or a strike, regardless of your policy preference as to how that game turned out. But I would like to bring up a case that illustrates the difference of a more expansive view versus a textual view. I almost said strict construction, excuse me. And so a more originalist view. And this is a case, and this is not about the merits of the policy. So I want to lay aside whether or not you're in favor of same-sex marriage or opposed to same-sex marriage. But I would like to talk about Obergefell versus Hodges, a 5-4 decision that was based largely on the due process clause of the 14th Amendment, and in particular, this notion of substantive due process, this notion of, and a fundamental right in substantive due process. And could you sort of explain and contrast the view of the majority versus the view of the minority, and what that might mean, not what only it meant for that case, but what it might mean for future cases?
Sure. The due process clause of the 14th Amendment is, the relevant phrase here is pretty brief. It says, no one shall be deprived of life, liberty, or property without due process of law. And that it's from that phrase that we get this doctrine that Rick is referring to called substantive due process. The idea is that this phrase, this vague phrase, contains within it protection for certain substantive rights. So it is that portion of the due process clause that the court has relied upon in finding a right to abortion, for example. So in locating rights within that phrase, and the equal protection clause is also relevant here as well. that no state shall deny to anyone, any person, equal protection of the laws. The court, that is a particularly controversial area, that substantive due process area, because it is an area in which the court, in which the court says for itself what it thinks those rights are, based on what it thinks contemporary values are at the time. So Justice Scalia was not a fan of substantive due process because he felt like, listen, it says no one shall be deprived of life, liberty, or property without due process of law. That's a procedural guarantee about what happens to you before your property or your life is taken away, for example. That it doesn't contain a substantive guarantee saying that the state has to provide you certain guarantees or the state through legislation can't do certain things. So on Obergefell, this is the New York Times headline problem. I think as that case got reported and as I heard my students even talk about it, even in law school, even after they'd become kind of acculturated to some of these things, people were presenting it as a vote on the court for or against same-sex marriage. But that's not what the opinion was about. What the opinion was about was who gets to decide whether we have same-sex marriage or not. With the majority saying that it was a right guaranteed by the Constitution, and so therefore states were not free, kind of in that Odysseus tying himself to the mast sense, that states weren't free to say that marriage had to be between a man and a woman. And the dissenters weren't taking a view. In fact, Chief Justice Roberts' dissent was very explicit about that. He said, those who want same-sex marriage, you have every right to lobby in state legislatures to make that happen. But the dissent's view was that it wasn't for the court to decide, that the Constitution didn't speak to the question, and so that it was a change that should occur through the legislative process. And indeed, many states were already moving in that direction and making legislative changes. So I think Obergefell and what we're talking about for the future of the court, it's really a who decides question. People often ask, and Rick and I talked about a little bit about this yesterday, well, in what cases might we expect to see this controversy of who decides? When would it matter? If Hillary Clinton wins, one example would be that the court, in a case when Chief Justice Rehnquist was the chief, decided that there was not a constitutional right to die. And it reached that decision. It was a substantive due process case, interpreting this phrase, no person shall be deprived of life, liberty, or property without due process of law. But the methodology that the court adopted there said, okay, we will recognize that there's maybe some substantive component to that guarantee. So we'll recognize something about substantive due process doctrine. But we will only recognize a right as one that's protected by the Constitution by substantive due process. I'm not talking about the First Amendment, Fourth Amendment, and all that. I'm just talking about the abstract rights that the court has found in that substantive due process doctrine. The court said, we will only find such a right if there has been a long tradition in America. See where the winds are blowing right now in society. We will look at American history and American traditions and say, yes, this is a right. For example, early substantive due process cases dealt with the right of parents to educate their children. That would be a right where the court could see, that sort of firmly rooted history. With the right to die, the court said there has been no long-standing tradition in America of protecting a right to die, and so we will not recognize that right. I could imagine that case coming out differently and that precedent being overruled if Hillary Clinton is president, because as we all know, there's a big push now, and I mean, we see this in other countries. We see it in Canada, we see it in different European countries, we've seen a big press for it in the United States, a press for a right to die. And I think that's going to be an issue when legislative change is slow, because people increasingly see the court as a political institution. When they can't accomplish things in the legislature, they try to litigate it and then declare a fast win through the court because they think it's faster to get it through the justices than to convince their citizens in the legislative process. So that's an example where the methodology of who decides would matter. If we're going to have assisted suicide, if we're going to have right to die, Some states have already gone that route. The question is that something that people decide on a state-by-state basis, or does the Supreme Court impose a national rule that tells some states you're not free to make it illegal to commit suicide?
That's really well put. I can tell you in our public policy class, I tell our students, we're having this conversation right now. And the example you gave on right to die is a real life one. One of my own, and I admit that there are a lot of people in the good room may disagree with this position, but one of the reasons I personally get concerned about not tying substantive due process to history and tradition is that then policymaking to me can become very unfettered based on just whatever you happen to think. For example, in the future, and this is more hypothetical, but I could see it happening, a case comes before the court in the future, and it's a substantive due process case, and you get 5 unelected lawyers who disagree with 4 unelected lawyers, and it could be, is there a fundamental right to health care? Mm-hmm. Is there a fundamental right to a living wage? Is there a fundamental right to housing? And in our class we talk about this. These may all be terrific public policies, and maybe Congress should pass a statute, or maybe the president should go to Congress. But the question that you raised earlier is a really big one, and that, to me, is that who sets policy for the country, and does the effect of judicial philosophy on setting that policy? So can you comment on how you see that maybe impacting real life cases beyond right to die?
Yeah, I think, let's see. So I think there are a number of areas. I can just tick off a couple quickly in constitutional law where that who decides issue would be big. And I actually think there's some in the statutory context that would matter a lot as well. I think the death penalty is likely, the court has had an uneasy relationship with the death penalty for a long time. It came very close to holding the death penalty unconstitutional in the late 70s, early 80s, and then as the court came back, the states that wanted the death penalty really pushed back, and then the court retreated. I think there's a question of who decides there. Is that a state decision? Is that a constitutional decision? I think right to die. I think abortion. I think people phrase the abortion question when they think about the Supreme Court as, is Roe versus Wade going to be overruled? Roe versus Wade actually isn't the law. It was superseded by Casey versus Planned Parenthood. But we've had 30 plus years of a court that did take, on the whole, a more conservative approach to the judicial role, and Roe versus Wade, Casey versus Pennsylvania, left Roe largely intact, reinstated a new test, but it's still there. I don't think that abortion or the right to abortion would change.
Do you think some of the restrictions might change?
I think some of the restrictions would change. I think that's what we just saw last term in the case out of Texas. States, after the Kermit Gosnell affair and all of that, states have imposed regulations on abortion clinics, and I think the question is how much freedom the court is willing to let states have in regulating abortion. I think the question of, the court has held that in some circumstances, states can render partial birth abortion illegal, very late-term abortions. I think that's the kind of thing that would change. I don't think the core case, the Roe's core holding that women have a right to an abortion, I don't think that would change. But I think the question of whether people can get very late-term abortions, how many restrictions can be put on clinics, I think that would change. I think another area which people often overlook is statutory. Justice Scalia cared a lot about statutory interpretation, and this idea, similar to his idea, it was of a piece of his view of the Constitution, which is that when Congress enacts a statute, the words matter, you interpret the words as they're written, and if Congress made a mistake, I'm not talking about a scrivener's error, but if Congress didn't anticipate everything that would unfold, if the circumstances change, the judge doesn't have license to change the statute. That is a who decides question that it falls back to Congress. I think a lot of the cases that we're going to see coming to the court now involve statutory interpretation. The court just took up that transgender bathroom case from North Carolina. That's a statutory question. That's a question involving the interpretation of Title IX. which prohibits educational institutions that receive federal money, which almost all of them do from the Department of Education, from discriminating on the basis of sex. And the Department of Education and the Department of Justice interpreted that phrase in telling North Carolina in that case that it had to permit someone who is physiologically a boy but identifying as a girl to use the girls' bathroom. That is a huge shift, right? And this is why it's made the news. That would be a big shift, and it's a shift from the prior interpretations of that statute, which said separating locker rooms and showers and bathrooms on the basis of gender were okay. That's a big shift, and it's a who decides question, so that's pending on the court, and there are a lot of reasons why one might say that's a public policy debate. People will feel passionately on either side about whether physiological males who identify as females should be permitted in bathrooms, especially where there are young girls present, and we've seen all these debates. It's a who decides question. When Title IX was enacted, it's pretty clear that no one, including the Congress that enacted that statute, would have dreamed of that result at that time. Maybe things have changed so that we should change Title IX. Maybe those arguing in favor of this kind of transgender bathroom access are right. That's a public policy debate to have. But it does seem to strain the text of the statute to say that Title IX demands it. So is that the kind of thing that the court should interpret the statute to kind of update it, to pick sides in this public policy debate? Or should we go to our Congress, should we go to our legislatures and say, if this is the policy that we want to have now we have a new recognition of the rights of transgender people, and we want to shift the policy, is that kind of sea change the sort of thing that should come legislatively or from the court? And I think we're going to continue to see cases like that. There's another case pending about doctors. I don't know if you followed this, Peter. There's a lawsuit that's been filed because HHS, relying on that same language in Title IX, has now interpreted the Affordable Care Act to require doctors to provide transitional surgeries and not discriminate if doctors and hospitals, including Catholic hospitals, receive federal funds, which they all do because of Medicaid.
So we're going to have some questions from the audience. I was actually, can we just maybe read them, or do you have some? Actually give the microphone to some people, for some of the people.
If you'd like to
sure.
Let me know if you'd like me to pass my sheet.
Sure. I will. We have some questions from the audience. Do you have a question, Richard? Go ahead. Microphone. Go ahead. No, my question is, here's a microphone.
We've talked about all these cases on the due process, but there are other amendments that are you have the whole concept of stare decisis, and how do you view the court's role in things like the First Amendment case? You have the Citizens United, which both sides are arguing, right, politically, not legally, and I guess it's a Heller case in D.C. about the guns. So you have all these different amendments, right, which are far from the 14th, but they have reasonably settled law. And how does that liberal conservative apply in those kind of cases, which are relatively settled?
Well, Citizens United and Heller are both fairly recent. So I think the court, stare decisis, the court is always at pains to say that stare decisis is a matter of policy, not inexorable command, is the language that it uses. So while the court, stare decisis is the principle that the court will generally not disturb the cases that it's already decided unless it has some good reason for doing so. And I think that Citizens United and Heller would both be vulnerable if Hillary Clinton wins, because they are cases which, in which the dissenters in those cases, who will still be on the court if those cases are revisited, felt passionately that the court got it wrong. And that is one of the factors that the court considers in whether to abandon a prior case. The reality is that because Heller protected the right to have handgun in the home, but it didn't say that there couldn't be other restrictions on guns, and the court has been giving a lot of leeway to restricting guns. I don't actually know if there would be as much interest in getting rid of Heller in particular, because most gun restrictions are still standing, but Citizens United, I bet, would be a pretty easy target.
Professor Race, really interesting question on this statutory construction issue. I think many people, including myself, tend to think so much about the Constitution itself, that is there a liberal or conservative approach to statutory construction? And one good case, I think, to maybe touch on briefly, would be King versus Burwell. A good example that is not a death penalty or social issue case, but healthcare. You remember there were two big challenges to the Affordable Care Act, the first one in National Federation, and the second one on statutory construction. And clearly, wasn't there a liberal and conservative divide in how to determine whether or not there was a federal or state exchange? Can we comment on that?
Sure.
But also in the sense of what this might mean, how a court of one persuasion or the other can have such a profound public policy effect.
Sure. So King versus Burwell was the second challenge to the Affordable Care Act, and it was a statutory challenge, not a constitutional challenge. Basically, the statute, the Affordable Care Act, provided certain subsidies, the tax subsidies. The language of the statute said that you got them when you purchased your insurance on an exchange established by the state. And state was defined in the statute to include the 50 states and the District of Columbia. It distinguished even between states and territories. Congress, when it enacted the statute, anticipated, because of the Medicaid pressure, the Medicaid deal in the statute, that all states would adopt exchanges, but then, as we know, the end of that story, many states resisted adopting exchanges. So the government, the federal government, had to set up some exchanges, and then the question was, well, gosh, the people who have purchased their health insurance from the federal exchange wouldn't qualify for the tax subsidy, and that could have a disastrous effect on the statute. Justice Scalia, like the textualist approach was, okay, well, maybe Congress didn't accurately foresee what was going to happen. Congress doesn't have perfect foresight. Or maybe Congress wanted this to be part of the pressure. Congress didn't really want a federal exchange because it looked too much like a single-payer system. So maybe this was an unseen bargain. Maybe what they wanted to do was pressure states to take the exchange, that the fact that their citizens wouldn't get the subsidy if they had to go to a federal exchange would have been some pressure putting pressure on the states to actually set up these exchanges. So Justice Scalia basically said, well, this is what the statute says, and now that events have unfolded so that it seems like this is going to have some bad effects for the Affordable Care Act, we can't go back and change what the statute says. But the other justices disagreed.
Kind of a pretty good example of the difference in construction between the two. Do you have a question?
Well, wasn't there an issue on the tax as well? I mean, only Congress can levy a tax, and the Supreme Court ruled in favor of it.
In the first Affordable Care Act case, yes, National Federation of Independent Businesses, there was a heavy statutory construction component to that case too, because this is not a tax, right, the individual mandate, but the court, in an effort, and the court in a good way tries to avoid constitutional questions, but the controversy in that particular case was that to avoid the Constitution, they very creatively interpreted the statute to be a tax.
Question from Eric Smith. Amy, we have a question in the back from Mr. Smith.
Thank you. How awesome it is to have a professor here from Notre Dame that worked with the great Justice Scalia, and thank you, Rick, and the Public Policy Institute for having her here and making this possible. I was an elected official here for 25 years and arguably the poster child for term limits. But I want to ask this question. I had some wonderful law students when I was a professor, and we got the impression in working with the cases from Justice Scalia that he held people like me, legislators, congressmen, in low esteem. Could you disprove that? And it's okay if you don't, but he didn't seem to hold congressmen and legislators in the highest esteem. That's my question. Thank you so much.
Wow. Let's see. He was not a fan of legislative history, to be sure. So he often took aim at legislative history. I never heard him disparage legislators at all. I mean, I think that he did sometimes question, a number of the court's doctrines call for giving deference to the constitutional judgments made by legislatures. And I do know that towards the end of his life, he had expressed skepticism that many members of Congress spent much time contemplating the Constitution and whether statute was constitutional before they enacted it. But I don't know that he had. I mean, he had great respect for the democratic process. So I think the logical conclusion of that to me would be that he also had great respect for those who represented us in the democratic process.
Professor Barrett, I have one last question, and I want to ask you for some closing comments, if you would. Here's the last question, actually, is I'm going to ask you to look a little bit into your crystal ball. In one of the presidential debates, the two candidates were asked about appointment of justices and what their concerns were for the future and what their priorities were. Hillary Clinton talked about abortion and Citizens United. Donald Trump talked about gun rights and Heller. And there's a tendency, of course, to look at those social issues in particular with a lot of emotion. But beyond those cases, looking to 217 and beyond, what are some of the significant matters that you think will come before the court and where the composition of the court could matter to the outcome?
Sure. I think right to die. Like I said, we've touched on some of them already. I think the statutory cases will be big. I think these Title IX interpretation cases. I think religious exemptions are going to be really big. I think, that was the Hobby Lobby case that Notre Dame was, and the Little Sisters of the Poor were among the religious institutions challenging the application of the contraceptive mandate. California, as a state, has mandated that all employers and insurers provide coverage for elective abortions. And they can do that as a state because the only basis for that challenge at the federal level was the Religious Freedom Restoration Act. We're going to continue to see those challenges. There's been a conscience exemption to doctors for performing procedures, abortions, or some of these transitional changes, performing mastectomies on women who want to transition to men. There's been a conscience exemption for doctors to this point. This lawsuit I was mentioning challenges that's being kind of dialed back. So I think on all of these things, these are kind of hot and heavy matters of public debate that we disagree about, that citizens are trying to persuade each other one way and another. And I think the question of who decides those questions, whether they're left to the electorate or whether the court and administrators decide them, is big.
Those are some great comments. You've kind of gone to my last, which is we're out of time for tonight. But I wanted to ask if you had any, given this historic point that we're at, I think the people in this room would all agree. This is a unique and historic time, that the election on Tuesday will be very consequential. People are talking about a lot of areas, but particularly for the people in this room in terms of the court and the direction of the court and the issues will be decided.
Yeah.
Do you have any comments as a constitutional law scholar and professor and maybe clerk for Justice Scalia as to your thoughts about the future of the court and where we're heading?
Gosh, it is a consequential moment, and the who decides question, just as a personal matter, is really important to me. And so I guess I worry a lot, about that who decides question about our decisions, or in my voice, kind of getting taken away depending on what happens, and that could be true, in either candidate's selection of nominees. But that, I think, is the question for me.
Well, on behalf of the Public Policy Institute, I have a little special presentation to make.
You.
I hope all of you will agree with me that this has been a terrific evening with Professor Barrett. Would you all agree with that? And we have two gifts for you. It's so nice not to be in government anymore where I can do this. This is one that will remind you of our Public Policy Institute, and this is something that we hope you just find is nice.
Okay, thank you.
But I will say, I hope all of you would agree that this fourth Hesburgh lecture was a very good one. I hope you've enjoyed the last hour. Don't forget to vote. Thank you all very, very much.
Thank you.